I think what we need to understand is why this technology is a little different. Because once you understand why this technology is a little different, you understand what some of the risks are, and that's directly relevant to some of the underlying ethical implications here for practicing lawyers. The ethical rules and the use of this generative AI, because you're going to be using it in a whole variety of legal tasks, from drafting to pleadings to communications, it implicates pretty much almost all of the professional rules. If you are now undertaking something that could be done by an engine, and the engine could do that task in substantially less amount of time, the client should get the benefit of the doubt and should be charged less.
Welcome, and thank you for joining us for another Justia webinar. My name is Lavinia, and I will be the moderator for today. Now, to kick things off, I wanted to introduce our speaker, John Rosenthal. John Rosenthal is a litigation partner at Shook, Hardy & Bacon, LLP's Washington, D.C. office, who represents clients around the globe in an array of litigation matters, class action, and multi-district litigation. He also has substantial experience defending clients before federal and state enforcement agencies. His focus includes business litigation, products liability, unfair competition, and false advertising. Mr. Rosenthal is one of the most experienced practitioners in the United States in the area of electronic discovery, information governance, and privacy. With this background, he counsels a wide variety of companies on record retention programs, compliance with electronic discovery, and the implementation of programs to reduce the risk associated with the generation and retention of electronic records and privacy. This webinar presentation will be approximately an hour, so if you have any questions that come up during the presentation, please feel free to submit them at the Q&A button in the control panel at the bottom of your screen. Now, without further ado, here is John to discuss generative AI in legal work, exploring use cases through an ethical lens.
United States District Court for the Southern District of Texas. Under Rule 11, the federal rules of civil procedure require an attorney to self-represent, that the litigant certifies that his claims, defenses, and other legal contentions are warranted by existing law, and factual contentions have evidentiary support. Attorneys and litigants are cautioned against submitting to the court any pleadings, written motions, or other papers drafted using generative artificial intelligence, ChatGPT, Harvey AI, generative AI services, without checking the submissions for accuracy, as certain technologies may produce factually or legally inaccurate content and should never replace a lawyer's independent judgment. Any attorney or self-represented litigant who signs a pleading, written motion, or other paper submitted to this court will be held responsible for the contents of filings under Rule 11, regardless of whether they're generated by artificial intelligence or drafted any portions thereof. The world has recently changed, everyone, with the advent of generative AI, and there are serious ethical implications to attorneys. So today's webinar is designed really to address a number of things, including give you a general background to what is generative AI, talk about some of the legal use cases around generative AI, review kind of the ethical rules, and then talk about some adoption best practices. When you look at some of the surveys and studies, this is the 2025 International Legal Technology Association. It says 85% of respondents said their firms are using and exploring generative AI in 2025. The most used tool is Microsoft Office's 365 Copilot, with 65% of the respondents saying they use it. 36% of the firms use CoCounsel Core by Thomson Reuters. Another substantial amount, 34%, saying they're using Westlaw AI. 33% using Copilot, 33% using Harvey, 29% using CoCounsel Drafting by Thomson Reuters, and the list goes on. About 1 in 5 firms are using a public version of ChatGPT, which we'll talk about, which potentially exposes a client's potentially privileged information and trade secrets, which implicates a number of ethical implications. many firms are using these tools without providing notice or consent from its clients. I think what you'll find out in this presentation, there are a whole host of issues here that implicate the ethical rules that really are just starting to unfold regarding the use of generative AI. With that said, generative AI is a incredibly powerful tool, and it is certainly going to dramatically powerful in the following respect. It's a transformative technology, transformative as the steam engine, transformative as the telegraph, transformative as the cotton gin, transformative as the creation of the smart telephone, the iPhone. This will dramatically change every aspect of business, and the legal field is no exception. It will dramatically change the legal industry as we know it in terms of both how law firms operate, how they practice, how they staff, and it will also dramatically impact how internal legal departments operate inside our clients. So all of this really changed in November of 2023 with the arrival of ChatGPT-3. And I don't have to tell any of you, it is hard to open up a website, open up a newspaper, and not that anybody opens up newspapers anymore, without seeing something about AI. And I think what we need to understand is why this technology is a little different. Because once you understand why this technology is a little different, you understand what some of the risks are, and that's directly relevant to some of the underlying ethical implications here for practicing lawyers. So I think the main difference you have to understand is that artificial intelligence is a very broad term, and people throw that around very loosely. What we're talking here today is really about generative artificial intelligence, because artificial intelligence has been around in some form for decades. And all of us are regularly using it, either knowingly or not knowingly, when we practice law, when we do legal research, when you use Google and run a search, when you use some of the traditional e-discovery engines. There's a whole variety of generative AI, of general AI that's built into these technologies that you're not necessarily aware is operating in the background. So we have to be careful that when we talk about the term AI, that's a very loose term. And what we're really talking about here today is generative AI. So let's start with really what it is. A general AI is for the most part, starts with the most basic thing, which is a foundational large language model. And there are lots of large language models. And if you see this slide, large language models have been around certainly pre-2022. And if you see what's happened in the last couple of years is you see an explosion in the number of large language models. So let's talk about this a little more specifically. So we a little geek speak, just so you understand what transformed with the introduction of ChatGPT-3 in November of 2023. First, you have machine learning. Machine learning is a branch of artificial intelligence that focuses on teaching machines to recognize patterns in data and make predictions based upon those patterns. Machine learning, again, has been around for decades. A version of machine learning is a large language model. And that's where an algorithm's been trained on a large amount of text-based information, typically scraped from the internet, such as web pages. And again, it recognizes patterns in those data and makes predictions against those. Now, again, large language models have been around for well over a decade. The problem with a large language model is that most large language models before November 2023 basically returned known data. So you could put a query into a Google and it would give you back a set of known results. And what it was doing was querying and returning known clear results. The dramatic change with ChatGPT-3 are the last two elements here. They took a large language model and they created a generative large language model. So that means the large language model is now generating new outputs based upon the pattern of data it's been trained upon. Let me repeat that. It's putting out new outputs. It's not, for example, querying the internet and giving you a list of known websites or known content. It's actually creating content. The other dramatic change in November 2023 was the addition of a generative AI large language model with a natural language chatbot. What does that mean? I call it AI for dummies. It means that there's a prompt line, kind of like a Google line, where you can put in natural language question, also referred to as a prompt, press the button, and it will give you a written response, almost like a conversation. That dramatically changed the whole nature and why this is so transformative, because not only can this generate responses, text, videos, computer code, but you don't need an IT person or a computer scientist to interface with the generative AI foundational model. Anybody can. So this is really AI for dummies. So how does this really work, right? When we say we have a generative chatbot. So think of it this way. You put an input in, a prompt, right? And then what's going on in the background is the brain, let's use ChatGPT, which is one of these foundational models, has scraped up a whole lot of information. In the case of ChatGPT, everything on the internet, right? And what it's doing is it is literally predicting the next likely word. So it's got a predictive engine built into it. So if you put in the word fourscore and, the engine is going to predict what are the likely next words. And based upon that probability, it's going to give you an output. Now, it's a combination. It's got a probability calculation inside the brain, and it's also got training, because what they've done is they've actually taken that, put in the query, looked at the probability, they look at the output, and then they literally have human trainers and then supplemented by computer trainers for thousands and thousands of rounds to say, okay, that's the right output, or this is the wrong output. So you get fourscore and if you look, the most likely next word is 7 years ago. Well, the thing about this is it does calculations, tens of thousands of calculations in seconds. So this is the way it is not only able to generate the next word, but the next 2 words, the next sentence, the next paragraph. So it can generate output incredibly quickly. And in the space of a few seconds, generate literally paragraphs of text in maybe a minute, pages of text. So I talked a little about training, right? So there's 2 kinds of training. The first is all of these big foundational engines, be it Claude or ChatGPT or one of the many others that I showed you on that big slide. They have what's called supervised training. That's when humans, and literally someone like GPT-3 or OpenAI, they hire hundreds of people who sit there and look at the prompts, and they train the engine for hundreds and thousands of turns. At some point, they then take that same foundational model, once they've had the human supervised learning, and then they train it against, they run computer training. So again, they run it for tens and hundreds of thousands of turns. So that what they're doing is taking that, all the information that you've scraped from the internet, and they're making these prompts and they're refining the training so that when you put in a prompt, it's pre-trained and it's honing down the information. So here's some problems though. And this is why this is really important from an ethical standpoint, right? It's trained, most of these engines are generally trained, and they're trained against the whole internet. And the quality of the training is going to vary. If you take the same prompt or question and put it in Claude, and you put it in ChatGPT, or you put it in Minstrel, you're going to get a different answer. If you take the same question and you put it in ChatGPT or Claude 3 times, you're going to get 3 different answers. All right. That's a big problem. The other problem is it makes up stuff. It literally makes up stuff. So when you put in a prompt and say, who is John Rosenthal? It may give you an accurate answer. It may give you an inaccurate answer, depending on the quality of the training. Uh, um, some of these models can hallucinate, falsify, make up stuff 50% of the time. The next biggest thing is it's not necessarily accurate, even though it may not be making stuff up. It may not, if there are multiple different options or answers to your prompt or question, it may not necessarily give you the right one. Another big problem is bias. If the model is trained on the internet as we know it, imagine all the nature. You have human bias, you have racial bias, you have historical bias. All of that bias is necessarily built in to the model. And depending on who the provider is, they may or may not have been able to train out that bias, and it probably are not able to entirely train out all biases. So you have to understand that every model that you're using is going to have some inherent bias built into it. That's pretty important if you're doing things like predictive outcomes of, like, for example, a case, or if you're using one of these models for any HR purposes. Um, because it can be easily manipulated, it can do things like create deep fakes, create false video, false copies of emails or SMSs. We've started to really see that, particularly in smaller cases, particularly in domestic divorce cases and those kinds of things. And we're starting to see a big concern among the judiciary about how do they detect and how do they deal with deep fakes. In fact, the Federal Rules Committee on Evidence is currently looking at the question not just of authenticity of Gen AI evidence, but also how do they address deep fakes, and do we need new rules around that? There are issues around defamation, copyright. There's issues around consumer protection. There's issues about, can an AI engine be a custodian for the purposes of discovery? There's issues about when you can use these things for regulatory compliance, and whether, if you use them, you may violate protections, particularly those around privacy. Lots of risks associated with this. So let me just jump back to hallucinations. Again, hallucinations are pretty important. And that's where people tend to get in the most trouble. We've seen a number of high profile cases, and we're up to 823. This is a website Damian Charlton maintains of all the reported decisions throughout the judicial systems in the world, where someone has submitted a pleading or piece of evidence that turns out to be based upon a hallucination because they used a generative AI engine to generate the brief or the piece of evidence, and they didn't independently exercise their independent judgment to validate the results of that. 823 cases, and new cases coming every week. So let's talk. So we've talked generally about what a foundational model is and what is a generative AI engine generally. And the big ones that you're used to, like Claude or ChatGPT 3 or Gemini. So let's talk and bring this down to a little more specific to the legal industry. So we have these foundational models. And again, they're trained generally on everything in the world. So how do you then take one of these models and then focus it on an industry specific? So what you're seeing is a number of providers come in, and what they're doing is licensing one of the foundational models, or in many cases, they now have the ability to, you can pick and choose the foundational model. And then they're putting an overlay, a specific application that interfaces with the model. And then they're doing supplemental training or some cases, what's called fine tuning around that. So you can take someone like Harvey, uh, or a Westlaw or Thomson Reuters, where they've taken a general foundational model and then they've specifically focused on a particular task and they've honed it for that task. In the case of Harvey, they've taken, which is a more generalized engine, they've taken it and really done a lot of human and supervised training around a whole variety of legal topics, be it written discovery, pleadings, legal concepts, um, um, uh, transactional documents. And you look at someone like a LexisNexis or Thomson Reuters, they've taken this and they've really honed it to um, um, legal research and other capabilities. And in some cases, what they've also done is they tried to backstop this with known databases of known information. So let's take Thomson Reuters and LexisNexis, for example. They're backstopping their generative AI research engine against their known databases of reported cases. And in that way, what they're trying to do is reduce the number of hallucinations and increase the accuracy of the engine, right? But those engines, we know, even though those particular engines are backstopped by known databases, still hallucinate. So that, again, is a big ethical problem. So what's the good news here? If you take one of these engines, right, and they're honed, you can do a whole variety of general tasks from just draft me an email, or summarize a document, and then you can hone them to specific legal tasks. For research, contract analysis, document drafting, document review, predictive analytics on case outcomes, administrative issues such as checking bills, generating bills, sentiment analysis to understand specific meanings, particularly in the context of discovery or an internal investigation, M&A due diligence, knowledge management, regulatory compliance. The list of tasks these can do, because they can generate an outcome, are pretty much endless for the lawyer. Um, and what we're seeing here, and this is one survey of really legal use cases, you can see that in terms of where people see the broadest adoption and broadest use cases are things like document review, legal research, document summarization, brief drafting. Let me just give you one practical example. I had a 144-page complaint in a class litigation that I'm representing a client in. I put the complaint, which was a public complaint, into one of these engines. I asked it to summarize it, give me a chronology of events, identify a list of players, identify the key claims, and identify a list of action points coming out of here. In 5 minutes, I got a Word memo. Needed about a half hour to clean up, but that probably would have taken an associate, 5 to 10 hours to do. That tells you how powerful these engines potentially are in terms of the legal industry. Now, if you're reading this stuff, just to further confuse you, if you're reading the internet, you probably have heard in the last 2 months, the next big thing is what's called agentic AI. And what agentic AI really means is what they're doing is they're creating workflows and tasks inside of these chatbots. So as opposed to you going into a generalized engine and say, um, find me the standard for summary judgment in the Ninth Circuit, it would be specifically focused on specific tasks and kind of presets that would allow you to do those tasks already. So the idea here, as opposed to these broad prompts where you may have to become what's called a prompt engineer, which means figure out how to ask the right question. Because often if you put the prompt in, you're not going to get the right response. So you'll have to reprompt and you have to continue to prompt. The idea of agentic agents is these agents will make the whole process easier, and they'll be really defined to do specific tasks or they might be able to put multiple tasks together and put together a single output. So in the case of that brief, you could create an agentic agent that says, give me an early case assessment of this brief. And it would do those multiple tasks, such as identify the key players, give it a summarization, give it a chronology of events, give it a list of action points. So if you're reading agentic AI, that's really the next step, which is the providers that are now jumped into these niches in the legal world are going to be developing these agents that do specific tasks across the legal spectrum. So right now, we have a lot of applications and more every day. They kind of break down in the legal industry, very generalized tools that aren't necessarily trained for the legal world, such as Copilot. Many of us are Copilot or Gemini, but you can use it for legal tasks. You can do things like summarize my mailbox, draft me a response to this email, summarize a pleading, summarize a deposition. Its ability to do these skills very widely in these generalized tools. And again, all of those problems that we outlined above are going to be, there's going to be a higher degree of risk with a generalized tool that doesn't have any legal training. The next are more generalized legal specific tools, such as Hardy AI, or ones that have been trained on particular niches. And if you look at something like LexisNexis or Thomson Reuters, they're really focused on legal research, although they're trying to expand to drafting as well as transactional documents. And then you have a whole variety of niche documents or niche tools that do specific things. They may draft a contract. They may do a particular kind of research, such as funding. They may do contract management as opposed to contract drafting. They may do regulatory analysis. And then the final thing is, you now have the ability to build some of these bots or agents inside some of these tools. You can either hire a vendor to create one of these agentic things, or for example, Microsoft has something inside of Copilot where you can create an agent inside of Copilot, and other ones are having um, uh, the ability to draft specific agents where you don't necessarily have to go out and hire a vendor and pay a lot for development and coding. So that's a breakdown of these tools. Before we get to, the rules, I just thought I'd give you a couple of thoughts about all these tools. The first one is, in any technology, you have what's called a maturity continuum. Like when some new technologies is created, it's relatively immature, and it's going to take a few years to mature so that the products become more sophisticated. In this case, do more, hallucinate less, validate themselves. And we're really at just the front end. What you're seeing is a bunch of providers rush in. The tools are fairly immature, but it's going to rapidly develop here. And why is it going to rapidly develop? One, because of the promise of this technology and its generative nature. And two, one of the things that these tools can do very well is they can write code. So in the old days, you would have to hire an engineer and they would have to write the code. So every time that you want to redo your code, called a scrum, it could take weeks. Now you can actually have one of these engines revise the code. So this code is being actually generated and regenerated in a lot of cases by these engines themselves, which is speeding up the whole development process. So we already talked about Copilot. For those that haven't seen it, there is a public version and a private version. That's very important when we talk about protecting client confidences and privilege. But as you can see, you'll go on there, you see the prompt window at the bottom. You see these are some pre-prompts where you can ask it and it will do a whole variety of tasks. Microsoft promotes this for use by lawyers. And as you can see, here's just a simple day in the life of lawyers where they say, here's all the different ways a lawyer could potentially use Copilot. You have MS Teams, which is part of the MS Office 365 suite, which is built generative AI inside it, the ability to not only record meetings, but generate a transcript, generate a list of action points. Again, there are a whole host of legal and ethical issues here, which is it okay to record? Are you in a two-party consent state? And what are the risks attendant to potentially recording meetings that you may later on have to reproduce uh, uh, in discovery? Or if an attorney is involved in the communications, to what extent are you taking steps to protect the confidential nature of those communications that are either being recorded or summarized later on? Hardy AI I already talked about. This is just a quick look at it. And this is one engine that is dramatically being improved. And when we talk about maturity continuum, if you look at Harvey 2 years ago when it first came out versus the engine today, it has been dramatically changed, where its performance has increased dramatically, as well as the task it's able to do across the legal spectrum have increased dramatically. Lexis AI, and again, there's Thomson Reuters also, but this is an example where you can ask it to do a whole variety of AI-assisted legal research as well as legal drafting. And one big area, particularly one I practice in, is the e-discovery space. And when you look at almost all of the major providers, from Relativity to Disco to Everlaw to Concilio to Alterni to Reveal, all of these companies have come in with Gen AI assisted e-discovery tools. And what these tools do now have the ability to write a very sophisticated prompt and then find relevant documents, find privileged documents, find hot documents, classified documents into buckets. Now, again, we're at the front end of this. I would anticipate within the next few years, the amount of first and second level review you're going to see done by where attorneys are actually looking at documents is going to dramatically decrease. But right now, we're at the front end of this, where the engines, the capabilities of these different engines vary widely. And there are no decisional rules around whether it's okay to use these tools. And if so, what is required in terms of discussions with the other side, negotiations with the other side, agreements with the other side, disclosures, et cetera. I thought using Relativity, what's called its Air Suite, I'd just give you a quick look at these. Again, I'm going to go through these very quickly. But these are some of the things that these e-discovery tools can do. As you can see, very powerful in the litigation space. Everything from deposition summaries to relevancy identification, privilege logging, confidentiality identification, PHI identification. Here's just a quick look. This is the Relativity Air Suite, where if you look at that column under predictions, it's actually making predictions based upon your prompt and training against the document set, whether or not it thinks the documents are responsive or not responsive. And then it's going to not only tell you whether it's responsive or not responsive or privileged, but it's going to give you the rationale as to why it thinks it's privileged and considerations around that. And it's going to actually point you to some of the language upon which it based its determination. So it can do relevance, it can do privilege, it can do confidentiality. And this is just a quick look at the confidentiality tool. Again, it tells you whether or not it thinks the information is confidential or does PII. It can suggest a potential redaction. It has another product relatively called Strategy, where it actually can look at a set of documents, create a chronology of events, put it into issue buckets, summarize the documents, create a fact outline. Now, again, these engines are moving rapidly. When this first was introduced, some of its capabilities were relatively weak. Over the last year and a half, Relativity has really refined this. And, you can put 10,000 documents in it, and in the space of minutes, you can get those documents organized by topic, as well as give you a chronology and list of key players, and then run queries against very impressive, very time saving. And this is just an example of where it's listing the documents out in a chronology. There are other products. There's a product called ClearBrief. It's designed for drafting fact sections, and it's also designed to do automated site checking. And it's designed to, if you take your record evidence in a case and put it in there, and then put a fact section, either yours or your opposing counsel, it will go through. And if you highlight a sentence, for example, it will give you a citation to every piece of record evidence that goes to that citation, and it will rank. In here, it's 1 to 19. It found 19 pieces of information to go to this first record site, and it ranks which of the 19th is the strongest and which is the weakest. It's a pretty incredible product. In the contract management review space, you're seeing literally dozens and dozens of products: Kira, Noetica, Thought River, Contract Ken, First Read, DraftWise, Spellbook, and the list goes on. And this is just an example where it can break down a contract into clauses, and then it can compare those clauses in terms of known clauses, or what it views as golden clauses, or what you believe to be the appropriate clause. So in terms of the contract drafting, considerable time saver or contract evaluation. So what I've tried to do very quickly here is just give you the world of what the technology is. I've tried to scare you a little that it presents a lot of risk from an ethical standpoint, and I've tried to give you a quick look that there are lots of tools available. But with great power comes great responsibility. So the bars have started to speak, and probably the lead here is the American Bar Association Formal Opinion 512. This is the lead opinion, came out July 29, 2024, on the ethical obligations around the use of generative AI by lawyers, both in-house lawyers, outside counsel. And most of the courts, the states that have adopted specific opinions are pretty close to, if not have adopted entirely, Opinion 512. If you read nothing else coming out of this presentation, I really encourage you to read Formal Opinion 512, because it deals with the following issues: competence, confidentiality, transparent communications, independent validation, candor towards a tribunal, supervisory responsibilities, informed consent, and fees and billing. And if you look at the states, right, this is, at least as of last month, the current states, and as well as we have the PTO here, that have issued opinions around the use of generative AI. Again, most of these are identical to the Opinion 512. There are some outliers here. If you're barred in any of these states, I'd encourage you to go read these specific opinions, but at a minimum, you should read the ABA 512 opinion. And this is just another breakdown of kind of the same guidance. So now, on top of the ethical opinions, I mentioned before that there are a whole host of standing orders, local rules, or decisions around the use of generative AI. The early ones were pretty much knee-jerk reactions that said you cannot use it at all. Most courts, I think all courts, have relatively backed away from that, and instead they're requiring some level of disclosure and certainly some level of independent validation to the extent that you're using generative AI in a case, particularly with respect to pleading, submissions, or representations made to courts. And that's the Ropes and Gray site that I referenced. And here is the Duke Bolsh Judicial Institute created something, a subpart of it called Rails, that's tracking all of these. And this is the Rails site where you can track and see all the applicable standing orders and local rules. So let's get down to brass tacks on the specific rules. This is a summary, and we're going to try and go into every one of these briefly, but the ethical rules and the use of this generative AI, because you're going to be using it in a whole variety of legal tasks from drafting to pleadings to communications, it implicates pretty much almost all of the professional rules. The duty of competence, the duty of confidentiality, the duty to appropriately supervise people that are using these tools, informing your clients about when you're using the tools and what tools you're using for. And there's a heightened duty with respect to certain kinds of uses, a duty of candor, both to the tribunal and to the other side. So this may require you to disclose when you've used it. And also, if you used it and find out that it did hallucinate, for example, you put a false citation into a document, you're going to have a duty to disclose that. What these engines can do or not do. For example, can they give legal advice? So far, there's only a handful of opinions that said that these engines themselves cannot give legal advice. Fairness to opposing counsel, fees and expenses. What can you charge for? When can you charge for it? What do you have to disclose about those charges? And the duty to avoid discrimination, because all of these could have inherent bias in them. So let's do Rule 1.1. A lawyer has to have a firm grasp on how electronic information is created, stored, and retrieved, and must know how to make and respond to electronic discovery requests and advise their clients regarding electronic discovery obligations, right? So this means that you, as a practicing attorney, have to have some technical competence around these rules, around the use of these engines. Do you have to become an expert? No. Certainly taking a course like this is the first start. In, I think, 2 or 3 states, there's actually CLE requirements on technical competence. So this highlights the point that if you're going to use these tools, you can't just open up a tool and start using it. You're going to have some obligation to understand what the tool does, what the tool doesn't do, how to use the tool appropriately, and what are the risks associated with that. So, a duty to exercise your professional judgment. This, probably of all the rules, is probably the most important rule. Because we know the problems with these engines, they can make up stuff, they can be inaccurate, they can be wrong, right? When a client goes to hire you, they're hiring you because of your independent legal judgment. So let's use legal research for example. When you use a generative AI engine to use legal research or draft something, you can't accept that wholesale. You have an ethical obligation to independently validate the results of that engine and exercise your independent judgment here. So like any tool that a lawyer uses, it's great to have a tool, but that's not at the end of the day what the client is hiring you for or what your ethical obligation is. Your ethical obligation is to exercise your independent judgment, which means to independently verify that the tool you're using is accurate. So you can't simply accept that it spit out this case supports this proposition because 1, it may not, and 2, the case may not even exist. The engine could just make up the case out of wholesale cloth. Duty of confidentiality and privilege is incredibly important here. Some of these engines are fully public. When you put the prompt in the engine, it goes to a public place. The response is public. And in some of these engines, let's take many of these engines, you can actually upload a document. So you could actually upload a complaint and say, summarize the complaint. Or let's say you have a long witness statement or a deposition. You could upload the deposition and say, summarize the deposition or analyze the deposition, or based upon the deposition, give me a list of questions. Well, let's suppose that deposition has confidential trade secret information or it's under seal. Depending on which engine you use, certain engines are going to sit behind a locked firewall in which only you have access to or your firm has access to. Other engines are fully public. So you could actually be potentially disclosing your client's confidential trade secret information or waiving privilege if you're putting information into a public engine and running prompts against that. So incredibly important that you take steps to understand what security is around the engine. Is it public? Is it private? What are they retaining? What are they not retaining? What are they disclosing? What are they not disclosing? Incredibly important here. Um, um, there are going to be lots and lots of cases where lawyers are potentially facing malpractice because they've used one of these engines without taking that into consideration. Um, and um, let's just look at all this. Many people say, well, what's the big deal, right? Um, because there's terms of uses, and when I sign up for the terms of use, the provider says, oh, well, uh, um, it's all protected and we're not going to disclose it. All right. Well, you need to be careful because are they actually complying with their terms of use? Have they actually wrapped technology around that would protect its disclosure? And this is a very high profile case that came out when the Anthropic uh, uh, litigation, where uh, the plaintiffs disclosed all the AI prompts and outputs which were relied on developing their lawsuit, but refused to disclose additional prompts and outputs. And the magistrate judge said, found that the prompts in this case were work product and therefore declined to order their production. But that's just one judge so far that has said when an attorney puts a prompt into an engine, assuming the engine even will protect it, does that constitute work product or not? Or is that fair game for discovery? While this is the one or two decisions that come out so far, I think you're going to see decisions all over the place as to whether or not the prompts and responses that an attorney puts into an engine, even if it's taking otherwise steps to protect its confidential nature, are privileged or not privileged. There are other instances in the copyright litigation where, for example, ChatGPT has been ordered to preserve all of the prompts and chats. And in fact, in one of those cases was ordered to produce thousands and thousands of those prompts and chats. Again, real big issues around confidentiality and privilege. Duty of candor. Again, here you have a duty of candor to the court. You have a duty of candor to your other side. And this goes back to your obligation to independently validate when you're using one of these these machines with respect to a pleading or submission, as well as if you discover that you actually made a mistake here and submitted something or made a representation which was generated by one of these engines that is false or incorrect, you're going to have an obligation to make a correction and make a disclosure there. A duty to supervise. So it's not just attorneys here, legal assistants, secretarial staff, paralegals, perhaps consultants that you've retained. Everyone is going to be using these engines. And it's not just the lawyer that has the ethical obligations. You as a lawyer has a duty to supervise your staff to make sure that they are otherwise complying with the ethical obligations here. That's going to be a question of making sure that in your organization you have the right policy regarding the use of these tools, as well as the right policy about when they can not be used, that you're making sure that people using these tools are using them in the appropriate way. They're using it consistent with clients' directions in a way that's not going to waive privilege, in a way that's not going to put a client's confidential information at risk. Unauthorized practice of law. We're really at just the front end of this, but I imagine, for example, that people will create bots where maybe, for example, you're constantly communicating with a set of clients in an industry and they ask a set of common questions. So you upload all your legal memos and you create a bot against the legal memos and you make it available to the clients so they can go in there and they can query and ask based upon your historical opinions that you've given the clients in that area, what the answer is. So, uh, uh, so I can imagine, and I'm aware of a few firms that have already done this, right? But first of all, is that legally protected communications? Right now, there's at least one court or two courts saying yes, but I think that's far from settled. But separately, um, your bot that you created could hallucinate, right? So uh, the bot, at least right now, nobody's recognized the bot or the AI engine as an attorney or a legal actor, right? Are you facilitating in the unauthorized practice of law when you create that bot and make it available to the client? Far from clear that we have an answer on that one. Those are just some of the key ethical issues here, and I'm going to back up to the overall list here. Of all of these ethical issues here, the most important ones in my mind are really the duty of confidence, which means you really have to understand what the tool does, what the tool does not do, and what the risks are associated with the tools. The next one is you really have to make sure that whatever tool you're using is protecting both the client confidential information as well as the privileged information. We did not get to the slide on the fees, but their opinion 512 really addresses the fee issue. And it's very clear when it's talking about the fee issue that you're going to have communications with your client about who pays for the tool, as well as are you potentially charging the client for fees that you shouldn't charge for. So, for example, it talks specifically about if you are now undertaking something that could be done by an engine and the engine could do that task in substantially less amount of time, the client should get the benefit of the doubt and should be charged less. So I surmise if you're like me, I've had loads of conversations with clients where they want to know, are you using the tool? Um, eh, uh, and who's paying for the tool? And how am I saving money on the tool? And can you quantify that? Which is really a difficult question when it comes to the quantification, because certainly these tools are expensive tools. So it's a question of, is the law firm paying for that? Is the client paying for that? Far from clear. Some clients have taken the position that some of these tools are overhead versus other of these tools, they probably have to go out and purchase those services in the open market. So they're willing to absorb some of those costs or pay for some of those costs. But because the tools are early on, it's very difficult for lawyers to put any metrics around what the cost savings are. I think generally the cost savings are that there's less attorney time needed for certain tasks because some of these tools, and therefore the clients are saving theoretically in billable hours as a result of using these tools. But again, far from clear how to quantify that and put numbers around that, which many clients are asking for. We also did not address the duty of informing clients and about the use of these tools. And the ABA opinion talks about that. There is a duty to provide, to keep your client informed. And that includes a duty to tell them that you're using these tools. Now, there's the concept, and opinion 512 talks about informed consent. Consent generally is something you can provide an engagement letter, although there's discussion in 512 about what you can put in an engagement letter or not put in an engagement letter. And there's caution about putting certain kinds of things in an engagement letter. But the general, when you look at all of these opinions, it's fairly clear that there's an obligation here to put your clients on notice of your intention to use these tools. Now, there is, at least in 512, a discussion about informed consent. And under what circumstances is there a higher level of consent required, informed consent of the client? And it's fairly clear based upon 512 that the obligation with respect to anything that has to do with informed consent can't be made in the form of a generic engagement letter. It has to be very specific to the use here and the disclosure and the consent the client provides. So in 512, it talks about informed consent is particularly required when you're going to put their privileged and confidential information at risk, particularly when it's being used to train the engine, right? So very, very, this is not an easy area, because when we go back to the issue of the training of these engines, right? So as a general matter, when one of these foundational engines or even one of these niche industry specific engines comes out, it's going to be trained generally on legal information, but it's not going to be trained on your client's information. You do have the ability to input either in the prompt or upload documents, for example, into these engines that it's going to have client specific, either privileged or confidential information. Now that in itself is not, you're not training the engine with that information. You're simply running prompts against that and getting outputs. But some of these providers actually make representations inside their service agreements that it reserves the right to take that uploaded information, either in the form of the prompts or uploaded documents, and further train its either niche application or the underlying foundational model with that information, right? So if you look at a standard service agreement, many will say we reserve the right to use any information that you upload or in the form of a prompt or document here to further train our model, right? You have to be very careful about that, because ABA Opinion 512 says in that case, you have to have specific informed consent from your client. The ABA 512 also talks about the fact that if the outcome of the litigation is going to be impacted by the use of one of these engines, then there's a duty of informed consent there. So very difficult issues around what discussion you have to have with your client, and what you have to have in terms of informed consent. My general advice is you should disclose to your client whether or not you're using Gen AI and what you're using Gen AI for. You need to be particularly cautious around uploading client confidential and privileged information. If you need to contract and make sure that your vendors or the suppliers of the Gen AI technology are not retaining your client information or for training purposes. And you need to have discussions with the client about how you're going to charge for these services. So closing up here, this is a question I get all the time. Is Gen AI going to replace lawyers? I don't think so. I think in a couple of years, law firms and legal departments are going to be dramatically different in terms of how they're staffed. I do think these engines are going to make lawyers better, more productive. But I don't think at the end of the day, what clients want and need is our independent legal judgment. And these engines are not going to replace that. But there are implications for everyone in the legal industry. For law firms, staffing issues, revenue, profitability, risk exposure for clients. How do we use our confidential information? How do you lower costs of routine tasks? Do you insource more work or outsource given these engines? What do you put in your engagement letters and your client guidelines? And for the businesses that we all represent, how does this impact trade secret protection? Who owns the information that to which these machines generate? How do you protect your trademark and copyright information? What risk does it put private information that we have an obligation to protect, such as employee or customer information? How do we modify our supply and vendor agreements to account for Gen AI and some of the issues around Gen AI? For litigation, there are going to be implications around confidentiality. For example, you need to know what your opponent's doing with your information. Is it taking the information you produce and putting it in one of these engines? And if so, is it a private engine or a public engine? Are they putting your information that you produced under a protective order at risk? Is your Gen AI engine a custodian? We don't know. I expect at some point in time, if you're using Gen AI engines in your business or in the legal department, you're going to get a request from the other side to say, okay, we want to sit down at your Gen AI engine and we want to run our own queries. Our privileges prompt right now, they seem to be, but who knows? Can you ask your AI assistant for legal advice? Again, totally unclear right now. And right now, the state and federal courts are already very concerned about how do you authenticate these records? Are they admissible? And at least the Federal Rules Committee has Rule 707 that is looking about the admission of this evidence, and also looking at further rules about authentication and deepfakes. Some best practices to comply with your ethical obligations, I would say, is understand the technology, understand the concerned security risk, mitigate the confidentiality and security risks through a policy, make sure that you're checking the quality of the results, determine what guardrails the engine has built in. And if it doesn't have built-in guardrails, are you going to use it? If so, what guardrails do you need to build around it? Going back to policy, I think every client and law firm needs policy. Policy is no good without education and training. So it's one thing just to roll out a policy, but when you roll these tools out, you have to roll out some education like this on general ethical obligations and then specific training on the specific tool about how to use it appropriately. And then you're going to have to figure out your communications, engagement letters, service agreements with your vendors. All of those are going to have to be revised to address these ethical issues and make sure that you're protecting your law firm, your legal department, and your clients. I have thrown an incredible amount of material at you, but this is an area that is very important because everyone, I believe, will be using these tools in their practice of law in the coming years. And it's very important that you understand what your professional obligations are regarding these tools. And I think some of these obligations will be further refined as these tools roll out. But I would strongly encourage everybody to read 512. And if you have any questions, please don't hesitate to reach out to me.
Fantastic. Thank you so much, John, for your wonderful presentation. It was incredibly informative. Now, if you guys have any further questions for John, please feel free to submit them in the Q&A panel at the bottom of the screen. I believe there is one for you, John, so far, in case you are still here and ready to answer the questions. If not, we'll absolutely wrap it up. All right. The one question that we currently have, the others are very lovely feedback, but the one question that we currently have is from an anonymous attendee who said, are there any recommendations for materials about HIPAA and summarization of medical records?
Yeah, well, HIPAA and medical records are particularly important because there's an obligation to protect them. There's all kinds of guidelines and HIPAA regulations about what you need to do in terms of limiting access. I would say that um, it's okay to use these tools um, to, for example, go in, look at them, and summarize them, and do other tasks, provided, right, you're using a tool that is private in nature, right? You don't want to go and upload a medical record to something like Gemini Public, right, which was going to expose that information and reveal that information. But let's say, for example, you have Copilot Enterprise, which is a private version of Copilot, and you have the appropriate protections around it. There's nothing wrong with you pointing Copilot at those medical records and prompting it either to summarize or run other queries. But what's really important, you need to understand, what is the body of information that I'm using against the engine? Is it privileged or otherwise protected? And then, regardless, what for the tool I'm using, you know, where does that tool reside, and what is it retaining? Right? Most of in the it's more expensive, but many of these industry specific engines are really sitting behind a semi-secure firewall like the Microsoft Azure firewall, and there's limited access. It's not open to the public, and they're not retaining the prompts and they're not retaining the answers. But you need to look at the engine, and if you have a security officer, have the security officer look at that. If you don't, there's a whole variety of people, vendors available that can help you with that to look at the security. And most of these providers have security documents. Um, and they'll provide you the security documents. But you also need to look at their vendor agreements, because sometimes their vendor agreements are written really for them, not for you. And don't just accept that boilerplate language.
Right. Thank you so much for that answer. Now, we do have another anonymous attendee who did ask which AIs protect your confidentiality, pardon me, if there are any AIs that do.
So you're gonna have to look. It's very, very confusing, because if you take some of the big engines like a Copilot or Gemini, there are public versions and private versions. So you have to understand which version. Many of the industry specific niche engines like a Harvey, um, um, or Contract AI, or they're they're localized engines, and they've addressed the security concerns. But I can't give you a long list. I actually have a long list. I've actually vetted probably over 100 different legal specific engines in the, so I have a pretty good idea, but um, you're really gonna have to figure out the specific engine and then ask those tough questions, because not all are created equal. There's one, for example, that I was looking at that did transcript summarization. It performed incredibly well, probably better than almost all the other ones. But they were using a public foundational model, and you're potentially putting at risk. If I have a confidential transcript, I'm potentially putting that at risk. So you just can't say, oh, look, it performs really well. It's built for the legal industry. There's no issues there. That's not necessarily the case, particularly as tons of providers rush in right now.
Understood. Now, we do have time for one more question. So, this last question that we'll be asking today is, for federal litigation cases, is there an AI that you recommend?
Yeah. So it really depends the task you're looking for. The best generalized tool right now, in my mind, is Harvey right now. Harvey doesn't do legal research, though. So then you got to either pivot towards Thomson Reuters or LexisNexis for legal research. If you're in doing e-discovery, um, um, I think that a lot of the engines are pretty close. Clearly, Relativity is the market leader right now, but there are other engines like as Reveal or Attorney that are very impressive. I've extensively tested all of them and used them for a whole variety of stuff. So in federal case and ClearBrief, I'll give a prompt to ClearBrief. I think in terms of the drafting tools for legal drafting of briefs and pleadings right now, while a lot of them are doing that, I think ClearBrief is the clear winner right now. But any one of these people can be technologically jumped anytime right now. This is just moving very, very fast.
Yeah, absolutely. AI is ever evolving. Thank you so much for everyone submitting your questions. And thank you so much, John, for answering these questions with such depth and such information. We truly appreciate it. Now, we do want to thank you and everyone else for joining us today for another Justia webinar, and have a wonderful rest of your day. Thank you so much, everyone.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.